Good afternoon, everyone. Day 5 of Washington Arbitration Week here in Washington, D.C. Today is December the 2nd, 2022, and we're very pleased to have the second panel of today. This is a great panel with a fantastic group of speakers, and I'll get to introducing our moderator in a moment. But I just wanted to say a few kind of admin details, but not details, actually important things. Here we are on our last day of what has been a fantastic week, really well-attended sessions in person. Our virtual attendance has also been excellent, and just wanted to thank all of our supporters over the course of the week for attending, and of course all of our speakers and our advisory committee and everyone who's put a fantastic effort again into making this a really successful week. And I think, not that it's a competition, but if we look at the various arbitration weeks that have kind of proliferated around the world, this is certainly, I think, from a content point of view and a participation point of view, certainly one of the leading ones. And I think that really reflects Washington as a center of arbitration. It really is a place that has certainly the institutions. ICSID is headquartered here, and we're very proud. And it's really the jewel of the international arbitration community. But international commercial arbitration is actually a very active practice here amongst our practitioners and arbitrators. We have a great deal of expertise and experience here in Washington, D.C. in all forms of arbitration and dispute resolution. And the fact that Washington truly is an international city really reflects on that practice as well. And it really, the great programs that have been put together with the assistance of our supporting law firms have really reflected all of that. And I just wanted again to thank all of our supporters. It's really been a great week. We have a few more panels today, and I think we'll finish off with a bang. And this next panel is one that I think has become a very important issue in all of dispute resolution in general, but certainly in international arbitration. And the title of the panel is, "What is an arbitral award but a piece of paper without enforcement, asset tracers to help leverage compliance, and funding to enforce and collect?" So a number of very critical issues. And I think we've reflected those issues in this panel. And I'd like to call on Will Maura from Validity to introduce our panel and moderate this panel. But just to give you a bit of background on Will, and I think Will really, thanks to Will, helped put together this panel. He works at Validity. He is a investment manager there. As you know, Validity works in the third-party funding field, and he describes it in his bio as sourcing investment opportunities from the country's leading lawyers and claim holders. And he is also actively engaged in Validity's due diligence and investment underwriting process. And Will, before he was at Validity, was at Cooper and Kirk, as well as having experience working at Bain and Company. Interestingly, Will is a former law clerk at the U.S. Supreme Court and has been recognized as a global leader in litigation finance by Law Dragon. So we're really appreciative of Will coming today and helping us put this great panel together. And I'm going to call on Will now to take the microphone, and let's get going. Thanks very much.
Great, thank you, Ian. And thank you to everyone for joining us today. Thanks to the Washington Arbitration Week team for this opportunity. And I really do want to take a moment at the beginning to just congratulate Ian, Jose Antonio, and their entire team, including Maria Lucia, Juan Pablo, and Ana Milena. I mean, so much work goes into putting together any conference, much less an incredibly successful one. like this one. And so I do want to recognize all of their efforts. And I'm excited about this panel. Jose Antonio and I discussed that we would need a really great panel if we were going to go head to head with the concluding matches from Group H. And I think that we have that here. So I'll introduce them, and then I'll kind of give a little bit of an outline of where we're going to go in the next hour and 10 minutes or so. And then we'll turn it over to some questions. So we've got 5 great panelists. We've got Sean Anderson from the Mintz Group, who's a director at Mintz and leads the company's Mexico City office. He has significant experience conducting complex litigation, integrity, due diligence, and asset tracing investigations in Latin America and beyond, and a particularly timely skill set for today. He also leads Mintz's cryptocurrency practice, where he's conducted investigations into thefts and hacks totaling in the hundreds of millions of dollars. And hopefully we'll have a few minutes to talk a little bit about that later this morning. He's worked in Colombia, he's lived in Spain, he's traveled throughout Latin America. He earned his MA from McGill University and his BA in Spanish and political science from Luther College. So welcome, Sean. We also have Jeffrey Commission from Burford Capital. He's a director based in Washington, D.C. He has 20 plus years of experience representing and funding claimants in investment treaty disputes and international commercial arbitrations under ICSID, ICSID Additional Facility, ICC, LCIA, SCC, and UNCITRAL. He previously practiced in the International Arbitration Group at Freshfields in London, New York, and DC. Jeffrey is also notable because he's a pretty respected and prolific writer in our field. He's authored numerous academic articles. He's the co-author of Procedural Issues in International Investment Arbitration and the forthcoming Third-Party Funding in International Arbitration. And he holds degrees from York, also McGill. So we have 2 McGill folks here, and University College London. So happy to have Jeffrey. We also have Matthew Kirtland, who's the co-partner in charge and co-head of disputes of Norton Rose Fulbright's Washington, D.C. office. And he also leads the Washington office's international arbitration practice and transnational litigation practice. He has first and second chair experience in international and domestic arbitration, federal and state court, and in international arbitration, he's handled proceedings across really the entire alphabet soup of panels: LCIA, ICDR, ICC, PCA, AAA, ICSID, and UNCITRAL. And he has a BA from Macalester College and a JD from Duke University here in the States. 2 more, Max and Ruth. So Max is the founder of Gordian Special Assets, an investment and advisory firm specializing in cross-border asset recovery. Gordian both purchases awards and finances international recoveries on a non-recourse basis, as well as conducting asset tracing investigations on behalf of other investors and law firms. Before establishing Gordian, Max led the asset recovery practice of an international investigative firm in London, where he led global enforcement and negotiation strategies on behalf of litigation funders and arbitration teams, and he holds an MA from the University of Cambridge. And last but certainly not least, we're delighted to be joined by Ruth Title, a specialist in international law and international dispute resolution. She's a member of the LCIA, a fellow of the Chartered Institute of Arbitrators, an accredited CEDR mediator, and a general editor of Arbitration International. She served as an arbitrator and advocate for clients, as counsel working on international tribunals, as an investor in companies with international arbitration claims, and as a scholar and editor of publications. She's also a polyglot, in addition to fluency in English, Spanish, French, and Portuguese are languages that she speaks. So we can conduct this in any language for her, but we will do it in English for me. And so delighted now to kind of turn over to the content here. Very briefly, so this is a panel about asset enforcement. We're going to take it in 4 kind of bite-sized quarters. First, we're going to talk about pre-litigation, how to think about asset enforcement and collection. Second, during the pendency of the litigation. Third, once you've got that judgment in hand, what do you do? And then fourth and finally, we have kind of a lightning round of a topic that each of our 5 panelists is particularly knowledgeable about. A lot of this is going to probably steer towards treaty arbitration and sovereign collection. But these lessons are going to be just as applicable to your commercial cases as well. So let's start there with phase one, before you sue, right? So before you even file suit, you might have a defendant. You hope that several years from now, you're going to have a judgment to collect against them. But that could be 3 years, it could be 5 years, it could be 7 years from now. And that presents some complications, right? Your defendant might be collectible today, but if they're a country, that country might be a respected member of the international community today. That might change tomorrow. The underlying political situation in the country might change. Your defendant might have assets today, but might secrete those away. And one of the difficult complications in this area is that there's so little public data. So Ruth, I want to start with you, and let's talk about what happens pre-litigation when a case first comes in to a lawyer, to a litigator. How can folks in the audience decide, as an initial matter, whether their case is even going to present asset enforcement risk? What are some of the red flags that might indicate that they're going to want to focus on collection efforts throughout the litigation and down the line?
Thank you, Will.
Not sure your audio
Here.
is working there.
So I guess I will.
Oh, there you go. Perfect.
Can you hear me now?
Yes, we've got you now.
So I think before answering questions about what the red flags are, just to speak more broadly about the state of the information out there, about enforcement. And when international arbitrations awards go unpaid, they leave the peaceful regime of mutual consent and international arbitration, and they enter into the realm of sovereign debt litigation or private creditor litigation. And in terms of sovereign debt litigation, those who specialize in chasing sovereigns to collect on their debts will tell you that most sovereigns pay their awards eventually. And they tout the regime because at the end of the day, sovereigns have no place to hide. Now, the reason why that's all true is because, as you know, I think there is no international bankruptcy regime for sovereigns, despite calls since the time of Adam Smith to create such a regime, and despite every once in a while an intervention from the UN, as in the case of Iraq in 2003, to protect assets. But there is no such regime. So at the end of the day, it is a matter of getting through certain sovereign immunity hurdles, finding the right jurisdiction, and finding the right commercial assets to attach. And so most sovereigns pay eventually. But I would like to talk about this word eventually, mostly in terms of its cost to rational business decision-making, but also its cost to peace, which is the reason why we have international arbitration in the first place. In terms of the cost to business, parties in international arbitration, and in particular, investor-state arbitration, are having to make key business decisions in the dark because of a lack of information on compliance with awards. So information on the time it takes to get paid, on the amount to budget for enforcement in the event of non-compliance, and how many cents on the dollar are actually can be expected to be collected at the end of the process. Just to illustrate the cost of non-compliance and the cost of enforcement of an investment arbitration award involving a sovereign, let's say you began an investor-state arbitration this past June, I like the month of June, in 2022, you're seeking damages of 100 million, and in 5 years, you get an award of 50 million, which, by the way, is not a bad result considering the latest statistics on how much tribunals are actually awarding in terms of damages. It's about 36%. So 50 million you are awarded in 5 years, and you're paid within a month. So the state complies with its obligation under the ICSID Convention to pay its award. So your internal rate of return on that capital that you deployed, 5 million for 50 million is 78%, which is wonderful. And your multiple on your investment is 10, 50 divided by 5. Now, but let's say that a respondent does not comply with its obligation to pay. You have to spend another 2 million to enforce the award because you need counsel in 2 jurisdictions to deal with set-aside applications. You need perhaps special counsel on sanctions. You want maybe to hire a lobbying firm because there might be a political angle. Maybe there's a trade agreement that's being drafted between the government of the investor and the host state that could be interesting. And you have to hire an asset tracing firm to find assets. So you spend 5 years doing this, you spend 2 more million doing this. And in 2032, after seizing the royal yacht, Princess Title bomb and the BVIs, a yacht worth 10 million, the respondent offers to settle the outstanding award for 45 million. So it was a $50 million piece of paper. You get an offer of 45 million and you take that offer because there are no other assets to seize. And this seems like a very good settlement. Now, if the tribunal had awarded an interest rate of 4%, which let's say that's the statutory rate of the host state, and it's pretty generous, post-award compound interest, 45 million would only be 68 cents on the dollar. So it's not 90 cents on the dollar because after 5 years, you really would have been owed 66 million. So accepting that 45 settlement offer in 2032, you've spent 2 more million. Now your IRR is 26.5 and your multiple on the capital goes down to 6.4. I'm sorry for these kind of ugly numbers, but let's just talk about this 26.5% IRR. For a lot of investors, that is a terrible return on an investment that is inherently risky and illiquid. That's not a good investment to make for 10 years in something that you don't even know. You don't know what's going to happen at the end of this 10 years. So, but in addition to the time value of money problem, not having information about the likelihood of being paid within a certain period of time adds a level of murkiness at all stages of the arbitration dispute, at all stages of decision-making, decisions about whether to proceed with the claim, whether to seek insurance to try to de-risk your claim and pay a very high premium, whether to seek litigation finance and lose a lot of the upside at the end, and deal with litigation funders, another person in your life, whether to how long the collection period will last, whether to sell your award on the secondary market to a hedge fund or a private equity investor. All these decisions are being made with really very little information. It's gut feelings, anecdotal information, and the best part, sovereign credit ratings that almost never correspond to whether the sovereign is actually going to pay an award. And Spain is the most egregious example of this. Spain being a top credit country that is one of the worst respondents to date in terms of flouting its obligations to pay ICSID and other awards. It's right up there with Venezuela. On the other hand, you have Ghana, which has not a great credit grade, fairly poor, not investment grade, that has had a fairly good record of compliance, and other small countries like Honduras and Guatemala that have complied. So this just doesn't make a lot of sense. So the fact that law firms seem to be
I'm not hearing her.
Yeah, I think you cut out again, Ruth.
Okay, thank you, Ricardo. Can you hear me?
Yeah, that's better.
Yes, yes.
All right. The fact that lawyers tend to be satisfied with the phrase, most sovereigns pay eventually, is not surprising because law firms are an input business based on billable hours, and they place no intrinsic value on data. I also find it not totally surprising that arbitration institutions seem to find little value in this data about what happens after awards are issued, because they also, I'm afraid, are input-based businesses based on volume of claims. According to a 2008, which is obviously quite old, survey by Queen Mary University, only 29% of arbitration institutions keep track of the awards after they are rendered. Sorry. So these numbers are troubling because, at least in the context of investment treaty arbitration against states, there is an increasing trend of noncompliance, and for political reasons, not because they can't pay, but because they don't want to pay, or they can't take the political decision to pay. So this raises a number of questions about what to do about it, and I'll leave it perhaps for later discussion about what the audience thinks now.
Yeah.
And there.
Thank you, Ruth, and thanks for that. I think running through those numbers is really helpful, talking about IRR, right, internal rate of return, which is just a function of what your return is on your money for how long it's been out there. And Sean, you want to say a few words on this? And given some of these uncertainties that I think Ruth has really done a great job of laying out for us, how do you think about advising your clients that are coming to you pre-dispute, pre-litigation? What does success even look like? And what should folks be kind of shooting their aim towards when they're engaging in litigation with collection efforts?
Absolutely. I think our mantra at the beginning is, and throughout really, is to hope for the best, but prepare for the worst in these cases. It's all part of a cost equation, like Ruth was saying, especially at the beginning, where you need to know your adversary, know whether they're previously been a challenge for enforcement, or whether you're going to have to invest more substantial resources to get your return on your dollar. And fundamentally, at the Mintz Group, we always obviously have an interest in it, but we really recommend conducting an assessment before you even file. It can be much more cost effective to figure out whether there is only one yacht to enforce against, or whether you're going to have a lot more targets to go after, and also to know, what other liabilities do they have? Are there other creditors coming after the sovereign that you're going to be competing against? So we liken it to a full body scan at the Mayo Clinic. You want to look at your opponent, set a baseline, identify known assets, known revenue streams, identify leverage points, which are also really important, and also map the jurisdictions you might need to be litigating in, or bringing the judgment to bear in. And so the other value add is this essentially sets up a clear record of the structure, the assets at that point in time, that later you can use to point to any fraudulent dissipation of assets that the state may be restructuring, or things like that. I think in certain cases, there's also a threshold where you can reach where a sovereign might eventually kick and scream and pay in full. But in other cases, no matter how much pain you bring to bear in your case, they may resist paying. And so we like to focus on monetization. Obviously, that's top priority, but we really do think about strategic disruption value as well in our investigations. Can we gum up the ability of the opponent to go about their day-to-day business and affairs? Can we embarrass them on the international stage? Can we cause problems with other creditors? Can we do anything, or can we identify points that we can bring them to the table and potentially save on the overall cost of the enforcement strategy? If you seize enough oil tankers, even Venezuela will come to the table. Sometimes they might leave the table after the fact, but at least you got them to the table for a partial payment. And so I think there's folks who are much better at quantitative analysis than I am, who are trying to find patterns in settlements and the likelihood of payouts, and projecting that. I know that people have been kicking that around, especially in the finance side of the business. But I'm not personally sure whether we've got a magic bullet on identifying those figures yet. Yeah.
And Max, you've got a similar skill set in many ways, and you've engaged with a lot of these cases pre-litigation. The best way to win a fight sometimes is to not have to get into a fight at all. An ounce of prevention can be better than a pound of cure. So what advice do you have for litigants who are trying to avoid getting to asset recovery situations in the first place? Is it simply a matter of avoiding high-risk targets, maybe even avoiding doing business with high-risk targets? Or are there other means available that you're aware of to kind of hedge or lower enforcement risk?
Yeah, I mean, I would say I would certainly echo Sean's comments about needing to conduct adequate investigative enforcement due diligence. And that means obviously on the asset position, but also really on the track record and the interests of your counterparty in general. So in terms of the track record, how have they generally reacted to other disputes? Have there been active enforcement proceedings, etc.? They generally the commercial transaction. Generally quite a good.
We are not hearing you.
Yeah, I think whatever we just lost you there for a bit.
Is it better now?
Yeah.
Yeah, maybe turn off the second mic.
How about now?
Perfect. Yeah.
Yep. Yeah, really doing your due diligence on essentially the characters that you're dealing with is very important. And then also the relationships with the external stakeholders that could affect enforceability as well. So obviously, as Sean mentioned, that could include other creditors. But then also potentially the political situation as well around your potential award defendants at the pre-claim stage. So, for instance, is there a risk of sanctions in a couple of years when you've actually got your award? That's something that has I think been very relevant in the last year as certain states are faced with new sanctions. Yeah, obviously, if you're dealing with a private party, you also need to consider the relationship with the stakeholders in the particular country where you're looking at enforcing against assets as well, and the relationship with regulators, etc. And if those are already stressed, then you may need to think about risk management from an enforcement perspective. Then, in terms of actually managing the enforcement risk, one of the things to think about is making sure you actually know who the right defendant is to bring your claim against as well. So you can bring a lot of grief by mapping you can avoid a lot of grief by mapping the potentially liable parties and assessing their relative attractiveness from an enforcement perspective before deciding to bring your claim. So, for example, if your counterparty is a company or a sovereign whose assets are all in a jurisdiction where enforcement is going to be very difficult, and there's another liable party, such as a subsidiary, a state-owned company, an ultimate beneficial owner with assets in enforcement-friendly jurisdictions, consider doing the relevant investigative work required to bring an additional ancillary claim against them. And that actually may be outside the scope of your original arbitration. Then consider using injunctive measures as well. This is probably something we'll touch on later, both as a way of preserving assets from dissipation before you get to your award, and also as a legitimate pressure tool to actually increase the chances of settlement, again, before you get into that post-award stage where settlement and recovery could become a problem. Then lastly, as Ruth mentioned, more recently, you also have insurance options to basically reduce the risk of non-compliance, particularly against sovereigns. As Ruth mentioned, the premiums tend to be very expensive, but if you're dealing with a potentially very high risk claim, it may be worth considering as well.
Great, thanks, Max. And I want to get Matthew and Jeffrey involved in the conversation here. Matthew from the litigator's perspective and Jeffrey from the litigation funder. And maybe Matthew will start with you. As the litigator, you're often wearing the captain's armband for this and putting together the right pieces on the field with you. So case comes in, client calls you, got a great case. I'm thinking there might be some asset enforcement issues. How do you, as the litigator, manage that risk from the start, right? And maybe one way to think about that is, what are the right pieces of the puzzle that you need? Is it litigation counsel distinct from enforcement counsel? And what are the other kind of service providers that you're going to need from day one as you know, the captain of the efforts here?
Yeah, can you hear me, William? Am I coming?
Yeah, we got you.
It's a fascinating question because ordinarily international arbitrations do not begin with an assessment of risk of collection. They begin with the substance of the claim. When dealing with ISDS, with the measure taken by the foreign sovereign. While enforcement is always thought of at the beginning, it's not necessarily the primary concern. The question for the investor is, do we walk away?
I'm
at
sorry.
I think we just lost you there again. Yeah.
Yeah. How about that? Is that better?
Yeah, that's better.
I think to be so, and there are lots and lots and lots and lots of cases where enforcement is not a concern at all.
Lost you again, unfortunately.
Now?
Yeah.
Could do this.
Perfect. Oh, no, it's not working.
So it is a
Beautiful. I
concern.
love it.
Lots of cases where it's not. In the two, when represent, you typically look at factors such as the type of opponent, the type of case, the size of the award. Larger awards, the $1 billion, have more enforcement. The 8 and 10-digit awards, when it says trick.
Sorry,
In terms
it's
of
pretty
man-
choppy. We're not getting much of what you're saying, unfortunately.
Try to get- How about now? Is that better, Will?
Yeah.
We now have.
Put them all
I've-
there.
Tripartite.
That's right. All right, there we go. But as to the specific question, what can one do at the beginning of the proceeding to manage this risk, other than what the other panelists have said? And I agree entirely with what Ruth and Max have said on doing one's due diligence. Picking the opponent, that's the respondent in the case. Max touched on that. That's absolutely true. There are oftentimes in cross-border international arbitration, a choice of respondent. Picking the jurisdiction in which the proceedings are instituted, that oftentimes also is a choice. Not as much in ISDS, but in international commercial arbitration, it can be. And as we'll get into later in the panel, there are, of course, significant differences in rules for both recognition and enforcement, as well as set aside and annulment, jurisdiction to jurisdiction. So not all jurisdictions are created equally. And then also one can think of not only the claim that can be brought, but the conduct during the arbitration. And I file this under the don't win the battle and lose the war. There are oftentimes strategic decisions made at the beginning of an international arbitration that are that can get the client a quick win on a procedural point, but ultimately will just set up years of headaches and defenses to enforcement and to execution down the road. So sometimes it makes sense to go a little bit slower up front in the arbitration itself, so that you have a more enforceable and clearer path to getting your award paid.
Yeah. I think that's a great point, and having litigation counsel that understands that importance of what is the long-term goal, not just the short-term goal, is essential. And I want to ask Jeffrey, who should be the most popular guy in the room, because he can write the check to help make all of this happen. Tell us, Jeffrey, about how litigation funding can help, in particular, pre-complaint, right? And Ruth walked through the IRR, that calculation that you're going to be familiar with, the uncertainties down the road of, are we going to have an enforcement problem? How long is it going to take? Is litigation funding a viable option for folks? How do you think about it? And what tips do you have for people who might want to get that pre-litigation funding to hire the Matthews and the Ruths and the Maxes and the Seans of the world?
Yeah, I mean, I think at the outset, the vast majority of claims that we see in terms of claims that are funded on a single case or a portfolio basis are at the very beginning. So these are cases that are in their early stages. So the RFA has not yet been filed. There's some diligence that has been done, but there's much more that needs to be done. So I would say a significant majority of the claims we see are at that very early juncture. If they are really attractive claims, and by really attractive claims, I mean it has a counsel team with the requisite expertise and experience. It's against a respondent that has a proven track record of payment and settlement. It's a claim where, if it's in the investor state context, the foreign investor made a significant investment, like in terms of wasted costs or the amounts actually expended in country. It's a figure that's, I would say north of 50 million. I mean, it's never the case where we want to invest more than the investor himself or herself actually invested. Yet, I can't tell you how many cases we see where claimants want us to put in more money than they did in a case. Because, and you just look at the jurisprudence, tribunal after tribunal looks at the amount, oftentimes it's a sanity check, as they'll style it, but they look at the amount that the investor invested and how far along they got in the process. Did they have a right to mine, or did they just have an exploration permit? Was it a going concern, or was it just very early days and very much a pipe dream? So any early stage opportunity, we're looking at the claim. So in terms of questions of jurisdiction, merits, questions of quantum. I think Ruth is right in terms of the world of publicly available data. There isn't much out there, and I think that's absolutely right. There is, however, privately held data on a number of these issues. I mean, we have a lot of it, simply because it's key to what we're doing. So we have the rates of settlement for sovereigns. We have the rates of payment. Again, it's not comprehensive data because that doesn't exist. I mean, and Ruth is absolutely right. I mean, ICSID keeps track of cases while pending, cases once registered, annulment proceedings. But once that is over, they don't track payment. They did years ago do a study. It was a survey, not on outstanding awards, but on outstanding cost awards. So they did a survey of responding, because this was at the request of Panama. It was a concern about cost awards that were unpaid. So they did a survey. And ICSID could easily do that to claimants as well. And they could publish those results on the ICSID website, so that you could name and shame certain respondents, but they're not doing that, but they could. But the results of that particular survey showed that, just like claimants, some respondents get an award and sometimes they just sit on it. So some respondents, and these are much smaller awards, obviously, they're awards of costs, but certain of those respondents just don't engage counsel. They don't proactively go after payment and go after the claimant. So there, on the data point, there is some data out there. A lot of it is not in the public domain. I do think arbitral institutions, particularly those at the forefront, like ICSID, could do more in that regard. And I think if we bring pressure to bear, maybe they will. But internally, there are a lot of analytics on tribunal members, on the track record of law firms, how many wins and losses they have. And you can break it down by firm. You can also break down, and Ruth is absolutely right on the amount of damages claimed versus awarded. It's on average between 36 and 38%, but it does vary depending on the sector. So PV cases, renewables cases, are a bit higher than that. Mining cases a bit lower than that. So when you apply certain sector paradigms, you can refine the analysis of it. one last point is when you obviously we don't pick the law firm, that's the prerogative of the client. But when you look at the jurisprudence, there are certain law firms that, for whatever reason, are quite successful both at the original arbitration proceeding and also certain firms that are quite successful at getting settlements from sovereigns. So it's not uncommon to see certain law firms with a history of settlements with respondent X. So one thing you may want to consider is, figuring out why that law firm is so successful in procuring settlements with that particular respondent. And if you're not engaging them, why aren't you? Because that may be one consideration to keep in mind. That there are certain sovereigns where if you're not going with a particular firm or a particular shortlist of firms, you really have to be, considering why you've chosen the firm you have. Anyway, I'll stop there for now.
Yeah, no, it's very helpful. And I know your LinkedIn feed is a very good source for a lot of that kind of data-driven approach. So folks should check that out. So we've appropriately, I think, spent a good amount of time on the pre-litigation. I want to talk very briefly, mindful of time, on during the litigation, and with just a few minutes on that, then go to after you've won that judgment, right after you have that paper. But I do think it's important to ask a couple of quick questions about what you can do during the litigation. So maybe first to Max and Sean, can you say just a couple of words about what tools, what people can be doing during the litigation from an asset tracing and searching phase? And then I'll ask counsel and Jeffrey. Max and Sean, you want to go first?
Yeah. Can everyone hear me?
Yeah.
Yeah. So yeah, firstly, from an investigative perspective, again, once you've done your full body scan, Sean put it, you already have a very good picture of the assets at the moment when you're initiating your claim. If throughout the claim you actually monitor those assets and the movement of those assets, that actually gives you two things. So firstly, this could give you an opportunity to obtain pre-judgment injunctive measures, identify a clear risk of dissipation. Obviously, if you're dealing with a sovereign, that might be more difficult to do. Secondly, just from a financial consideration perspective, it means that once you get to the award, is that better? Yeah. Thanks. Means that once you actually get to your award, you don't have to start from scratch again in terms of establishing the asset position at that point, and how that's changed in the 2 to 3+ years that it's taken you to get to that stage and get through the set-aside proceedings, etc. Then, yeah, in terms of injunctive measures, as I mentioned before, freezing orders, provisional attachment of assets, that kind of thing. Firstly, it will prevent any asset dissipation in a particular jurisdiction where you've obtained that. And secondly, it will give you potentially some settlement leverage on your counterparty as well, which obviously can shorten the period during which you're arbitrating and reduce the overall cost as well. You will obviously need evidence of a real risk of dissipation there, often that you have a good arguable case, and if you want to get it on an ex parte basis, which you generally do, you need to demonstrate a real urgency of obtaining these measures as well. So that might require some more ongoing investigative work as well. Then, depending on the facts around the case, you might want to consider ancillary civil and even criminal litigation as well, as that might open up, firstly, additional injunctive tools, but then also additional discovery tools as well. So just to name an example, in Switzerland, if you're a civil plaintiff, then you can actually join a criminal case in which you've been damaged, and the prosecutor may actually be able to share his case file with you, which can then potentially give you access to things like Swiss bank account data, which is notoriously difficult to come by. So if you have an angle of that nature that you identified via your investigative work, it's certainly worth looking at that. Then obviously in terms of discovery, if you can start doing that early, then that obviously helps. And again, the investigative piece comes in. So start looking at the banks that your counterparty might have a direct or indirect relationship with, other third parties like payment processors, etc. Potentially commercial counterparties if you're dealing with a sovereign. And again, that can really give you a head start on the enforcement process if you can get that started ahead of time, essentially. And on top of that, those measures can be extremely intrusive to your counterparty as well. They can bring to light information that they would rather keep under wraps, and so they in and of themselves can serve as a settlement pressure tool as well.
Sean, is that consistent? I mean, what are you doing on these cases where you're retained while the litigation's ongoing and they've decided to go after this target, but they don't know if they've won yet? I think you're on mute. Yeah.
Absolutely, I agree with a lot of, if not all of what Max has just said. I think once you've entered into the process, it's critical that you really, if you haven't done the MRI, you do it right away. The process of an investigation is iterative. You're mapping things, then you're digging in deeper and seeing essentially kind of the process of how a payment might be made, in what jurisdictions it's coming from, how you're going to actually be able to enforce against it. And so I think it's important that you're ready to hit the ground running as soon as you have the award. You want to have a list of low-hanging fruit that you can hit, more liquid assets that you can grab, and then identify the more challenging targets that you might be going after down the line. Our investigations essentially can consist of working through the deep paper trail of the adversary, but we also start talking to people, and depending on the stage of the investigation and the stage of the arbitration, you might want to stay quiet, or eventually once you've initiated the process, then you're a little bit more comfortable rattling cages and talking to people that it might get back to the adversary that you're talking to. And so, beyond that, this is kind of the second step where we're taking what we already identified and we're looking into the nitty-gritty of how, a fiscal agency agreement might be set up, or how, a revenue stream, whether it comes through Canada from a parent, or whether it's paid locally and isn't worth focusing on, and things like that. And then, as Max said, if you can pursue any sort of freezing orders or things like that at this stage, we would absolutely recommend that.
Yeah. And Ruth and Matthew from the litigator's perspective, and Ruth also from the arbitrator's perspective. I mean, Ruth, can you say a few words about, as litigation counsel, when you're doing the block and tackle of litigation, how much of your mind share, how much of the audience's mind share should be around collection? And then, you have experience as an arbitrator. How much are arbitrators thinking about this as they're kind of going through and welcoming or not welcoming at all, litigation efforts that are looking ahead to the collection stage?
Well, I think what's certain is that in light of the Supreme Court decision on 1782 discovery, what I think we're going to see a lot of is strategic litigation in parallel to investment arbitration in particular. So, and there is a common pattern, a somewhat typical pattern in these disputes, where the sovereign cancels a concession, so takes from Peter to give to Paul. And so I think what you're going to see a lot of is a lot of litigation against Paul to get information about the asset and also about recovery. I can't say how arbitrators really think about all this, but I just think there's going to be a lot more parallel litigation, and even ones that you wouldn't pursue before, all avenues, just to shake it up. I think that's going to happen.
Yeah, and Matthew, to that, and let's say I'm your client and I say to you, look, my bills are high enough already for litigation. I don't want to worry about asset enforcement right now. We'll worry about that if we win, because I don't know if we're going to win yet. How do you manage that tension, and how are you thinking about collection when you don't know if you're going to get the award yet?
I mean, it's your decision, Mr. Client. I mean, it's a cost-benefit analysis. But you have to know that oftentimes in these high-profile cases, a little bit of investment up front on asset identification, which Max covered, preparation of papers in advance, and then getting the right team together, maybe several $100,000, maybe circa $1 million of investment, could put you ahead on the line of other creditors going after these same assets. And this oftentimes is a rush, and priority does matter. The rules of priority are incredibly complicated. They're not the same from jurisdiction to jurisdiction. And you have to make sure, if enforcement is a risk, that you're prepared and you have the right team. But if you don't want to pay that money, and you want to take the risk that after 5 years you'll collect nothing, then that's your choice, of course. We would recommend against it in particular cases. But again, going to the sort of the opening points, there's lots and lots and lots of cases where you are not really worried about enforcement as the case progresses, including on funded cases. Or you're worried about it, but there's not much you can do about it. No case is the same. Some justify millions upfront. Some you can get by with very little investment.
Yeah, and I think that point about priority is a really important one, and folks should at least be thinking that through. And maybe the answer is it's not important to get your place in line. And Jeffrey, if I've got a case funded with you, what are you doing to help your clients that you're funding pre-litigation during the litigation to ensure that you're going to be able to enforce? What are the ways that you're assisting there?
Well, I think it's important. I mean, every funder is different. And I think clients appreciate that when they are in negotiations with various capital providers. I mean, we are passive capital providers. We are not counsel. We do spend an awful lot of time looking at the track record of counsel to make sure that it's the right team in place. They have the experience, whether it's for the original arbitration proceeding or for enforcement. Oftentimes, it's not the same outfit. But once the case is ongoing, we try to add value. So we make suggestions about whether, on key strategic points, whether it's selection of the arbitrator, whether it's an application for security for costs, whether it's questions of disclosure. These are things we see in every case we fund, and we have a large portfolio of cases. So, and we do have a large network of folks in the arbitration space that we can contact regularly to get views on an arbitrator X or the success rate of certain applications. So we provide those to counsel. We also make recommendations for enforcement counsel if needed, or counsel. Oftentimes, you may want to have a particular firm running the global campaign, and then you're going to have local counsel in various jurisdictions where you're going to have applications. Typically, if there's a risk of assets not being there at the close of the hearing, or at the beginning when we're looking at a case to fund, we will engage our asset recovery team based out of London to get an initial assessment. And then during the course, I mean, oftentimes we'll include it in certain cases. It will be part of the budget that we agree. There'll be a budget for the original case, and there'll be also a portion of that budget ring-fenced for annulment and or enforcement. And it may be that at the close of the final, in the year, in the 12 to 18 months after the close of the final hearing and before the record is closed and the award is imminent, we'll get a couple of reports done. And oftentimes AR firms will do these reports for free in a form of beauty parade exercise. And you can get a good phase one report while you're waiting for that award. Because otherwise, counsel is pens down once the cost submission is in and the PHBs are in. So you want to make use of that time, I would say. One last thing is, if you look at how particular sovereigns act, and you can follow, and these are oftentimes reported about, but certain sovereigns will settle cases when certain actions are taken, whether it's freezing correspondent bank accounts in New York, that there's a certain sovereign that when you do that, you see a settlement within a couple months, or whether it's, we saw this the other day, there was a plane seized in Tanzania. There's certain things that have proven to be effective to lead to settlements, both generally vis-a-vis any sovereign, but also vis-a-vis particular sovereigns. So there are roadmap, so to speak. Now, obviously, you have to keep in mind that the fact that it works, the fact that it worked once means that particular sovereign is going to probably make some modifications so that they don't get taxed again. But there are playbooks out there that claimants, I think, can use, and we try to direct them in that way while they're, for instance, waiting for that award to be issued.
Yeah, that's really helpful, and it's important to recognize here the funders are investors, and so they have an incentive to invest time and energy throughout the case to think about enforcement, which I think you hit on well. Great. Well, so now I want to focus on phase 3. Right? We decided to pursue the case. We won the case. We got a judgment. Right? And I want to start with Matthew on this and tell us procedurally what you're doing and strategically how you're thinking about those next procedural steps. So you get the award. Are you working on enforcement right away? How do you, in the treaty cases in particular, how do you think about enforcement going in parallel to annulment as well? What are you doing in that first week to 60 days after you win the award?
The answer, I think, is yes. Demand for payment, immediate petition for recognition or confirmation, depending on the type of the award, multiple jurisdictions, and your team is already assembled. So yes, you, unless it's a very small case or there's not, or you are thinking strategically, the case is going to settle or there's a reason not to proceed vigorously, then yes, once you get the award, you should proceed, typically without waiting for the resolution of annulment or set aside proceedings. Of course, most judgment debtors ask for a stay, but that's not always given. And whether it is given depends on jurisdiction to jurisdiction and case by case. But that's the general approach at the beginning. Some of the more elaborate strategies that we've talked about a little bit come later, but those are the first things that should be done.
Yeah. And Ruth, you have a lot of experience with this as well. Tell us, how you're approaching the enforcement phase as litigation counsel. And you did a really helpful analysis at the beginning to kind of set the stage for everyone from kind of an economic point of view. How are you advising your clients on that issue, and how does settlement come into play here, right? How do you think about, do I take that settlement that's a bird in the hand, or am I going to try to push forward for enforcement of the full amount or closer to the full amount?
I think you have to do all of it. And some experts, and I think they're right, believe that you should have a separate team for settlement. You have your aggressive litigation team, and then you have your nice folks on another team, and not to mix it up. So of course that costs a lot, and I don't know if other people share that view, but it makes sense. I mean, so the problem with enforcement is not revealing your cards. It's very tricky. It's like the Kenny Rogers song. You can't reveal your cards too soon. So it's really a dance in terms of, and really Matthew and others are the experts in terms of what you pursue and what you don't, and the timing. It's sort of not, it's very hard to summarize it.
Yeah. And when you talk, Ruth, about the settlement team and the litigation team, is the litigation team the same as the asset enforcement team, or how should clients think about whether it's a new counsel that needs to come in once they've got that award?
It certainly can be. There are some lawyers who just have a particular expertise in enforcement, and not in the international arbitration. It depends on the firm. There are some lawyers who specialize in sovereign debt litigation, who specialize in chasing sovereigns for all kinds of debts, the sovereign bonds, and they understand it very well. And there are some lawyers who are more like litigators, who are doing international arbitration and don't have as much expertise in sovereign immunity rules and in just the strategy that goes on, which is really complicated, I would say.
Yeah. And Jeffrey, one thing you can do is you can settle. Another thing you can do is pursue the award. Another thing you can do is call a litigation funder and see how they might help. And I know that a lot of what you look at are purchasing judgments or funding judgments. Can you tell us a little bit about that? What is it? How can a litigation funder help me once I have this judgment? And what is the funding process to get that funding look like?
Sure, I'll deal with the easiest first, and the easiest is really providing funding for annulment and enforcement, which is pretty straightforward. We would provide a certain amount of capital based on a budget provided by a council team that would fund the enforcement and annulment efforts. We would do modeling based on how long we think it'll take. We know how long exit annulment proceedings take. We know how long set aside proceedings before certain national courts take, and we would look at how long we think it'll take to collect. And obviously, a lot of that is driven by what council's experience and their recommendations, and our own internal experience. And that's probably the most straightforward, providing straightforward annulment funding or enforcement funding. There is increasingly, and I say increasingly not because this market is new, but what is new is just how mainstream it's become. Investor state awards or commercial arbitration awards have been the subject of, they are, like anything else, assets. And they have been bought and sold for some time. What's new is it really is just like funding now is part of the mainstream with both the ICC and ICSID, the two leading institutions in terms of investor state and commercial arbitrations, adopting rules, acknowledging the use of arbitration finance. The monetization of awards is now really in the mainstream. You've got, last year there was an award creditor who had an award of over $1 billion that publicly said to its investors, we're pursuing 3 strategies. Number 1 is enforcement. Number 2 is settlement. Number 3 is monetizing. And that's what this company told their investors. And that wasn't the case 10 years ago. It was something that was not in the public domain. So you have companies announcing it. You have increasingly it's being the subject of submissions in ICSID, for instance, in ICSID ad hoc committee proceedings, because you have respondents seeking stays of enforcement, and you have respondents saying that there's a risk of non-recoupment because they understand that the award has been sold. Now, in most cases, the award is not assigned. There's a participation agreement, so it's not a real risk. But in those decisions on stays of enforcement, if you read carefully, you can see what's going on in these transactions. And if you read carefully, you can also see the pricing. In at least one decision, there was a reference to the pricing that one particular fund had paid to buy this award. We have all that information internally, both what we paid, what others have paid based on what we hear in the market. But increasingly that too is coming in the public domain. So you've got companies talking about it. You've got ICSID ad hoc committees talking about it. It's also coming through in certain enforcement proceedings, because in certain courts, depending on the nature of the monetization agreement, there may be a need to disclose that transaction. So it may come up in that sense. So it has really become mainstream. It doesn't begin when the award is issued, to be clear. It begins months before that, because it usually begins at the close of the final hearing. We typically know, depending on the tribunal, how long it'll take to get an award, or at least a range, and then we'll reach out to claimants. Sometimes in cases where funding, there'll be an option included to monetize any eventual award. So it's not, this market doesn't begin as soon as the award is issued. Oftentimes there are deals in place upon the day that award is issued. These deals are very bespoke. They vary depending on the needs of the client. In some cases, it's payment all up front and they want out. In others, they want 3 tranche payments. One to be paid within 10 to 15 days of closing, another to be paid upon the close of the annulment proceeding, and another to be paid on collection. So there's a fair bit of variety. But the big takeaway, I think, is just this is becoming particularly commonplace. I think we'll just see more of that in decisions of ICSID ad hoc committees, and as companies consider this as a legitimate corporate objective with an asset that is an asset like any other.
Yeah, yeah, a lot more options available now to claim holders than maybe there were 10 and certainly 20 years ago. And Max, you know, speak to that a little bit, right? As the business owner, I know you have some thoughts on this, right? How do they think about the value of their award? How do they think about whether to sell, to self-fund, to call Jeffrey, to get insurance, which you mentioned earlier? You know, you sit in a lot of, you can buy awards, you can help folks enforce their awards. How are you advising your clients who are calling you, you know, maybe right after the hearing or after they got the award on weighing these different options, which is a nice problem to have, but it's still a problem.
Yeah. So yeah, I think it's very important to think about how the award sits within the business. You know, if you have a party that's actively evading payments and has an extremely complex asset structure, which typically means that it's going to be very time consuming to manage the enforcement process, and that is going to require some very niche expertise, both in the asset recovery process and in the process of actually coordinating the asset recovery team as well, which will typically mean counsel in many different jurisdictions. Then, you know, potentially you may be better off assigning that task to another party, having them fund that process, and, you know, focusing your time and really the money that you've got from the monetization of your award, if you sold it to them, on your core business and, you know, getting that back up and running. And I would say this is where enforcement funding really differs from pre-judgment litigation funding as well. And that, you know, as Jeffrey mentioned, you know, most funders and investors that focus on the pre-judgment stage really are passive players and are set up to be such. If you want to be buying awards, then really you need to you step into the shoes of the claimants effectively, and you have to be actively managing this process right up until the point where you get the settlement, which is a very different consideration. And that's what we're seeing a lot from clients, is that they're really looking for more than just capital in these situations. They're actually looking for a party that can step into their shoes and manage this. From a profit split perspective, which obviously is a consideration when you consider whether to get your case funded or whether to sell your award, if you were to structure your claim purchase with an earn-out structure, where there's essentially a profit split upon the payout for the purchase of your award, then you can get a very similar type of profit splits to the one that you might get if you were just entering into a litigation funding agreement. But you have the benefit of potentially having to do far less of the work in terms of managing the recovery process. Equally, if you do want to keep the award in your books and manage the enforcement, I would say there are now far more ways of keeping more of the recovery for yourself as well, and giving less away to your funder. Obviously, the first thing that you want to do is look at the law firms that you're working with and the extent to which they can agree to a flexible fee agreement. And secondly, look at potential insurance options as well, not necessarily on the arbitral award default insurance front, but also on the AT insurance front, which can make it far easier for your law firm to take a fee risk, essentially.
Yeah.
Then finally, in terms of actually structuring a sale, it might actually make more sense for you to sell the entity holding the claim, as opposed to selling or getting funding for the claim itself. That can avoid some jurisdictional pitfalls. So, for example, in a lot of non-sovereign claims, you may be bringing an ancillary fraud claim in multiple different jurisdictions. If that will take you to jurisdictions like Ireland or Singapore, where litigation finance is generally prohibited, then structuring the investment as an investment in the company rather than in the claim can really help get around those types of issues.
Great. Yeah, that's really helpful, Max. And Sean, maybe the fun question for you, tell us what's actually happening on the ground when we're doing the asset enforcement, right? what are the different types of tools, of strategies available to folks like you who actually need to go out and find those jets, find those boats, find those bank accounts, those, you know, give us a sense of what that day-to-day looks like.
Yeah, so once we enter into the enforcement process, we work hand in glove with counsel, depending on what the priorities and strategy are for enforcement. So it's a lot of answering targeted requests that are needed for filings, but also, you know, continuing to work from ideally the initial snapshot that we have of where the assets are. Are there any new structures being set up? What are they being used for? And so it's a comparative exercise in some respects at that point. But we're also doing other tasks at this stage, looking into veil piercing analysis on certain entities. Is there a, you know, a state-owned entity that we want to go after, or things like that? And so, you know, we have cases that have gone on for years, even more than a decade, where we've been actively working with counsel on enforcing against major awards, and those cases also involve a lot of monitoring of any new changes with the adversary in the case. And so, you know, fundamentally, we are looking to move from our public records work, find into new jurisdictions where there might be other assets that we haven't focused on because perhaps they're less friendly jurisdictions than our favorites, but they still could have targets that are worth looking at. And so it's a lot of, you know, reviewing in detail different filings, litigation filings that may seem irrelevant, but could have a reference to a banking relationship that, you know, isn't available in any other place on the internet. And so we look under every, you know, possible, in every possible, you know, nook and cranny that we can find to find information. And then we, as I said before, we're talking to perhaps a former employee of the, you know, the finance ministry who might be willing to speak with us, or an adversary that had a dispute with the subject and they are willing to inform us about how the payment structure worked. And we also use some really interesting newer tools. We're partners with Graylist Trace, which is a really fantastic tool that allows you to target banking relationships using email servers. So it's a very technical tool, but essentially it identifies whether an email has communicated with another institution. So initially they started with banking relationships where you could see whether I had used a certain email to contact Citibank, for example. And so if my email was whitelisted by the bank's email server, there's an indication that we've communicated. And they have newer techniques that also let you do that, looking between two different individual emails. So you can see whether two individuals have contacted each other. And so we use those, and those have actually been used in Norwich Pharma Call orders, 1782s, and have been really powerful for us in identifying potential banking relationships. And we also use, depending on the case, geolocation data. So we have a technical partner for that as well, where we might be able to see that the CFO of the subject entity had recently made a trip to the BVI and visited a particular office that we might want to focus on. So, you know, in some cases, we're jet setting around the world and talking to people on the ground. Other cases, we're finding interesting stuff in public filings that we can save you all the time of reading and find all the little details you need for enforcement. So it's, you know, this is like you said, for us at least, it's a very fun stage when we're you know, actively helping trace tankers around and watching when they turn off their transponders, and then identifying where they're going to go into port next. And there's nothing better than helping put an attorney on the ground to be on that dock when the tanker arrives.
Well, yeah, thank you for that, Sean. And that does seem like one of the more interesting aspects of all of this. So we've got 15 minutes left. What I'd like to do is cover as much ground as we can, kind of dual tracking two things. First of all, folks in the audience, we would love to hear any questions that you have. So anyone live, anyone by Zoom, I think you might have the ability to just kind of turn on your camera and ask a question, or otherwise, if you want to put it in the chat. So is there anyone who immediately has a question, maybe anyone live? We can take that. Otherwise, we'll kind of dual track and cover as much of our lightning round questions as we can.
I wanted to pick up something on that how the credit rating will say be whether states are paying or not. You see, especially in PE cases, international institutions like the IMF or the World Bank playing the role in encouraging enforcement or encouraging payment of ISDS.
So
Can you please restate the question as well?
So the question
before you answer.
referring to sovereign credit rating and the misalignment between paying awards, your question is, do the World Bank institutions have a role to play in nudging sovereigns to pay? And this is also murky business. We don't really, it's not entirely clear. Of course, I have had experience where some clients, even where a sovereign had withdrawn from ICSID, insisted on going to ICSID against a South American state. And the reason was because this South American state, the perception was that it would respond and settle, and it did. So the idea of the World Bank, the presence of the World Bank, so whether it's in connection to a loan agreement, but I think the atmospherics are there. And I think that there are certain Central American states also which have this strong record of compliance because they're small economies and because there is that presence. The IMF is there. Maybe this will affect, but I don't think there is an actual, the world, ICSID is completely independent. So ICSID would say no, but whether the perception matters, I think the answer is yes. For certain countries, and other countries, of course, they're not members of ICSID. So,
thank you. I think that Jeffrey mentioned the attachment of the Tanzanian plane, and we saw earlier this week that a Dutch court confirmed this attachment despite the fact that there was a stay of enforcement in the ICSID case. So my question is, I think it's more for Matthew. Would you recommend pursuing the enforcement of the award in Dutch court, for example, despite the fact that there is a stay of enforcement ordered by an ICSID ad hoc committee?
Would we recommend pursuing enforcement worldwide if there is a stay of enforcement ordered by ICSID? Well, there are certain instances where stays of enforcement ordered by tribunals or judicial bodies or quasi-judicial bodies like ICSID bind the person. And so to do so would be a violation of law. We would never recommend that. There are other instances where the option is open. And as long as the benefit outweighs the risk, then yes. Doesn't often come up, this situation. What more comes up is the case is in annulment, and then your question is, shall we proceed with enforcement while it's pending with annulment at ICSID? And the answer to that is usually yes, except in rare circumstances.
And we have a question in the chat here. Could you speak to the notion of compliance in kind? For example, that a sovereign might be willing to overturn the disputed policy, and a claimant might find that sufficient to stop enforcement. Is this a common point of discussion in settlement processes, and how do investors think about that as well?
I can give that one a go if you like. I think that really comes into the business discussion in terms of what you're really looking to get out of the dispute. For example, if you're actually an operational business and you're actually looking to get back into business in the country in question, then it could actually be something that you should really consider. For example, if you're a mining company, there was an expropriation, and your rights may be returned to you. Obviously, from a funding point of view, that might make things more complicated. And there again, there are ways of structuring this more intelligently as well. So, when you're looking at listed companies that are still operational and have a claim against a country where they might want to restart their operations, if you have a more kind of flexible capital provider, they might actually look at taking a stake in that listed company, and potentially getting a board seat and looking to help with the management of the enforcement that way. And in that sense, they obviously share in the upside if the share price increases in the company that they've invested in. So yeah, I would say definitely it's something that one should consider. Obviously, for a party that only does litigation finance or enforcement, suddenly becoming the owner of a Danish donkey farm or something, that they then have to either either manage or sell off, which might be a very long and complicated process, and not yield very much in the long term. That might be a slightly more difficult discussion to have.
And if I could just add on that, I mean, it is oftentimes it's said that third-party funders, their involvement can inhibit or forestall any potential settlement in cases where you have non-monetary compensation being ordered. And I disagree with that. I mean, I think our agreements, and I think most funders' agreements, have a clause that has a valuation procedure in place for a settlement that is non-monetary. So it just means that, for instance, if there's a license that's been reinstated, that there'll be a series of returns that are paid over time. So it's not that just because the outcome is not an immediate cash payment that the funder is not content. No, it's actually something that's contracted for, and there's a procedure in place. So I just want to make that point clear.
Yeah, I think it's a great point. I mean, no funder is going to want the litigation to continue when there's a settlement like that on the table. So that makes total sense. Any other questions? We've got one more in the chat here. Would you mind explaining a bit more what kind of criteria related to the investor itself are considered by the third-party funder when deciding to take on a client in international arbitration? And what kind of investors tend to use third-party funding in such cases? So maybe for Jeffrey, what criteria are you looking at, and what are the types of counterparties that you're seeing?
I think there's been a change over time in the cast of characters or types of counterparties that we have seen. I mean, when I started as counsel in funded cases, and this was back in 2010, it was the claimants were the impecunious claimants that could not otherwise have brought the arbitration, but for the funding. Fast forward 12 years, and a significant majority of our claimants are not the impecunious. It's more the exception than the rule. And increasingly it's large multinationals, Fortune 100, Fortune 250 companies that have claims and are looking at funding as another way to offset legal risk. So I think the kinds of claimants that are, and you'll see this more, I mean, with the new rules on disclosure and the requirements for certain listed companies to make announcements in the event of material developments, and we have started to see it with the ICC's rule that you start to see more of the funding that's going on. And oftentimes it's, particularly in certain sectors, like for instance, the mining sector, there were a number of very large arbitrations for which funding was announced during the course of last year, that are companies that did not need the financing. But it was something that they considered. But in terms of the diligence that we do, it's like we do on any part of the case. We do diligence on the client, just like a law firm would do on a know your KYC basis to make sure, because it's a long-term relationship, particularly in these investor state cases. I mean, the average case is 3.86 years. Tack on another 2 for annulment. Tack on another God knows how long until collection. It's a long-term relationship. You want to make sure, just as much as that claimant wants to make sure the funders are around, we want to make sure that claimant is still around and liquid. So, we want to meet them in person. We want to look at their financials. We want to get a sense of how they got to the point at which they're seeking funding.
Great.
I think we have a question live here.
Please.
So my question is, from the point of view of third-party funding, I come from India, and we're sort of looking at drafting regulations for one of the SEZs back home. And my question is, from a risk management perspective, how much would the absence of an Arkin cap sort of, factor into your decision to fund a litigation in a specific jurisdiction? And are there, specific steps that you might then take, for instance, getting a lock on, costs before you actually get into arbitration, or getting some sort of a deposit before you actually get into arbitration that might factor whether or not you decide to fund a specific litigation?
So in terms of that, I mean, the segment of the business for which I'm responsible is very much the arbitration space. So these are investor state and commercial arbitrations in which the third-party funder is not a party to the arbitration and over whom the tribunal has no jurisdiction. So in all of these cases, there's not the possibility of a cost award ever being rendered against the funder because the funder is not a party to the proceeding. There are, of course, cases where if a particular respondent is involved, or a particular claimant is seeking adverse cost funding or adverse cost coverage, that will be something that can and will be folded into the facility, into the package of funding that is provided. And I think there's probably likely to be more of that now that with these new disclosure rules, there's definitely going to be an uptick in the number of applications for security for costs. Even though the vast majority have been proven to be unmeritorious, there'll be an uptick in respondents seeking that. And there may be claimants in the face of a decision from a tribunal that says, you need to pony up whatever the figure is in order for the case to proceed as security for costs. And, as funders, it's unfortunate that that's where we are. But quite frankly, as long as you can make a return on that, like in the event you're successful, as long as you can make a return on that 1.5 million and it's not just sitting there, that it's not the worst outcome. Because again, these are cases that we've diligenced and that we think are quite attractive. So the idea of having to add more capital, as long as there's a return associated with it, it's not the end of the world.
Yeah, I think it comes back to the due diligence point as well, and just knowing where you will actually be enforcing, and the potential extra costs that are associated with that. And yeah, for example, if you're going to have to post a bond, that kind of thing. And yeah, if you can price it in at that stage, then the decision becomes much easier. Obviously, if you get surprised at a late stage, then that can really throw off your entire budget. And we've seen cases get torpedoed by that kind of thing, for sure.
I think we have 30 seconds left, and I just want to say, Sean, one question to you for the Q&A. Interesting time to be the head of crypto for a company. People are probably interested, can you actually recover stolen crypto? Maybe just give us a few words about that before we wrap up.
Yeah, it is indeed a good time for business, not so good for crypto consumers and users. But you can indeed recover against crypto defendants. We use Chainalysis. We're a strategic partner of the Chainalysis platform, which we use to trace all sorts of different cryptocurrencies. And essentially, I've compared it in the past to being able to see all the transactions between Swiss numbered accounts, but you can't tell who is behind a numbered account. And so we are able to look at a database of all the public blockchain information to trace where funds have gone and where they could be targeted using legal process at an exchange or another hot wallet or a hosted wallet service. Basically anywhere in the real world is where you can pursue legal process. But the one thing that is interesting and semi-novel that people have used for enforcement in the crypto world is you can actually, with certain coins, get a court order to freeze things like Tether, which is a dollar coin, or USDC, which is another stable coin, even if they're not in an exchange. So you could go to court and ask the company behind USDC to blacklist a wallet that might have funds that you are going to pursue recovery of. So there are ways to do it. It's a novel area, lots of new case law being made around the world, but it's kept us quite busy lately. I enjoy it because I'm that kind of nerd, but yeah, we're happy if anybody has crypto related cases, I'm happy to discuss them anytime.
Yeah, and we need to close there. Ruth was going to talk about collective financing of sovereign debt, Jeffrey about ACMEA, Matthew about how to structure business contracts and relationships to avoid some of this, and Max about some of the countries that you can and cannot go after. So if you want an excuse to reach out to folks after this, there's a question you can ask them. Thank you so much to our amazing panelists, to the Washington Arbitration Group again for hosting us, and to all of you for spending some of your morning, afternoon, or evening with us. So we appreciate your time.